I finally got to do the interview with the lawyer for the lawsuit that is challenging the CIA's spying on people who visited Julian Assange while he was living in the embassy, the Ecuador embassy in London. This is a lawsuit that has been filed against the CIA and former CIA Director Mike Pompeo in his private capacity. And the plaintiffs are Deborah Hrbek and Margaret Ratner-Kunstler, who are attorneys who in some way or another represented Assange or WikiLeaks and had meetings at the Ecuador embassy with Julian Assange. And then there are two journalists that are signed on, and those people are John Goetz and Charles Glass. Charles Glass is a journalist who's had work published at The Intercept about the Assange case. And then John is a journalist who has worked for the German newspaper Der Spiegel. Der Spiegel, you'll recognize, was a partner. It was one of the three partners that was involved in the Afghan and Iraq war logs, and then also published coverage of the U.S. state embassy cables, the diplomatic cables. And so these are four Americans who were allegedly spied upon with the support of the CIA. We know they were targeted by UC Global, this private security company. Now this lawsuit will unfold in order to dig deeper and uncover more information, hopefully, that can help them challenge the violation of their rights, which occurred when they were meeting Julian Assange in the embassy. Before we get to those interviews, though, I just want to make sure that you become a subscriber of The Dissenter and the Unauthorized Disclosure podcast if you have not already. Support this work, support work on whistleblower stories, independent journalism that digs into those truth tellers who are challenging corruption that is particularly within U.S. government institutions, but also we've been doing some coverage of whistleblowers who are challenging corporations, which are clamping down on people's rights to organize, form unions, engaged in protective activity that should be permitted, but we know that they won't because it poses a threat to their bottom lines, to their ability to squeeze as much profit out of consumers as possible. Why don't we begin just very basically? What's the status of this lawsuit involving the alleged spying against people who visited WikiLeaks founder Julian Assange when he was living under asylum in the Ecuador embassy?
Yeah, thank you for having me. So the current status is we have filed a complaint, which has received a tremendous amount of attention for good reason. And we are in the process of serving the complaint. The summons and complaint. We served it on Pompeo. We have served it on the CIA, which is essentially the United States Attorney's Office. It represents the CIA. And we are in the middle of serving it on the two Spanish, one entity and one individual, but the two defendants who live in Spain. So once we do that, we have a conference scheduled for, I think it's January 17th, and we will essentially set a roadmap for discovery and ultimately the trial of this case.
And as of right now, one of the issues for a case like this, when you were proving that people's rights were systematically violated, particularly when you're involving the Central Intelligence Agency, you have to have standing. Do you think that the people, the Assange visitors who you're representing, the two journalists, the two attorneys that you're representing, your case, if you went into court tomorrow and you had to prove to a judge you had standing, what would you say to the judge?
So great question. I like how you artfully asked it. The bottom line is I would say the following. I would say we have 4 U.S. individuals, all of whom were on embassy soil, that is diplomacy soil, and each of whom are protected by the Fourth Amendment. The Fourth Amendment provides protection from any search and seizure, whether you're in the U.S. or whether you're in Bangladesh, for any U.S. citizen. Here they happen to have been in London at the Ecuadorian embassy, and they, because they're U.S. citizens, have that right to not be violated, not be invaded by the CIA or any governmental entity. There's a process, Your Honor, and the process essentially requires the CIA or whoever it may be that wants to tape record conversations to go in and get a search warrant. They have to show probable cause. They have to go before a judge. They have to get an order. Only upon those events can they go and actually listen in on conversations or copy conversations. Without that, it gives a standing, and it's a violation of the Fourth Amendment.
Mm-hmm. And just to make sure I cover all the bases up to this point, are there any responses from the lawyers or attorneys that'll be representing the CIA or any? I know you sued Mike Pompeo in his private capacity. Have you received any response?
We have not. They have been radio silent. One thing that we know, which gives us tremendous confidence, is that there's a lawsuit pending in Spain, and El País, the newspaper, which is the largest newspaper in Spain, reports on it frequently. And we've amassed a series of information from that Spanish lawsuit. So we're very comfortable in our position. We believe we can prove what we need to prove, but to date, nobody has given a response.
And part of the lawsuit that you were filed is enabled by some of that journalism that has been done, as you're saying. You know, we have El País who has investigated. We've got the Yahoo News report from September of 2021 that laid out some details, actually made Mike Pompeo a central figure in challenging. Now, those, so a lot of the evidence that you're bringing into court, a lot of it's public right now, but by bringing this lawsuit, you believe that there will be an opportunity for a discovery phase in order to investigate and try and uncover even more detail on the violations of people's privacy rights, right?
Yeah, we believe there's a tremendous amount of discovery. We believe that there are hundreds of communications by and between the defendants, which went into the New York and Washington at a minimum offices of the CIA. We believe we're entitled to all those communications. We also believe we're entitled to what they actually imaged. Remember, the allegations are that when you went to the embassy, you gave the embassy personnel every computer device you had, whether it be a phone, an iPad, a laptop, and they imaged everything while you were meeting with Assange. So we will be able to get a tremendous amount of information, and we are looking forward to the judge giving us the opportunity to get that.
And I know that in your lawsuit, one of the things that was laid out was that you believe that this could have potentially affected over 1,000 people from the US who you could consider US persons in one way or another. I just put that in perspective in terms of like a case involving people's privacy rights. I mean, what does that really mean? What does that number mean?
So the number is for anyone that visited the embassy. Remember, Julian Assange was in there for 7 years. He had friends, he had family, he had doctors, he had journalists, he had people that he worked with visit him, and he had lawyers visit him. So that number is not all U.S. citizens, meaning they can't all be plaintiffs. But people have come forward since the filing of the complaint saying, hey, I'm a U.S. citizen. I want to be a plaintiff. So it means a lot because not only did, as alleged, not only did the CIA and Pompeo violate the Fourth Amendment by wrongfully taking information of the lawyers and of everyone, but they also violated, there's a lot of other things they violated. For example, every attorney has an attorney-client privilege. If I represented you, any communications we would have, be it oral or in writing, are privileged. Well, by going in and listening to the conversation between Assange and either Ms. Hrbek or Ms. Kunstler, the CIA essentially violated the sanctity of an attorney-client privilege. Not only that, but if they went in and imaged, as we allege, the computers of these lawyers, then they have attorney-client information of the lawyers which don't even relate to Assange. So Deborah Hrbek has a memo to a client in her computer, and the CIA actually imaged it. Then they have additional information from which have nothing to do with Assange. Add to that the fact that he saw doctors, so they have doctor-patient information. So there's a lot of information that we think they have, all illegally, which we want.
And then, of course, there's the two journalists, right? You've got Charles Glass and then John Goetz, correct? And those two individuals, as journalists, at least as far as the norms that are accepted within society here in the United States, is that you should not be explicitly targeting those individuals. And I suppose it's worth pointing out, while this lawsuit is unfolding, that it's now been codified by the Justice Department that they are not supposed to target journalists. That is to allow them to become collateral damage in prosecutions, whether those involve leaks or other criminal investigations. And so there could not be a justification for for targeting your two journalist clients. I mean, I suppose they could argue that in retrospect they did have the justification if they think they were spying on them in the context of a criminal investigation. But I mean, by and large, those people we accept are entitled to their privacy, correct?
Absolutely. So we have journalists that went in that interviewed Assange, and they went in, and the CIA went and took that. Could you imagine what it does to investigative journalism if an
Yeah.
investigative journalist is concerned that he's being tape recorded by the CIA? And on top of that, even there are doctors that went to see Julian Assange. So there's a doctor-patient privilege, which he has. If he's going to see a doctor for an ailment or an illness, why in God's name would the CIA be entitled to that information? So yes, the journalists, the doctors, the lawyers, it's just really, really inappropriate, and it's overreaching. And the irony is that has indicted Julian Assange for essentially wrongfully disclosing information. Now, in the meantime, what is the CIA doing? They're worse than Assange because they're wrongfully taking information. So yeah, it's interesting how what's good for the goose, as they say, is not necessarily good for the gander.
Right. And so you mentioned we've mentioned that there are people who have come to you who say that they were spied on too. Is there any likelihood that this gets certified as some kind of a like class action because there are a number of people who have been targeted allegedly?
Yeah, it does. There are people that have come to us. Some of them we exclude because they aren't U.S. citizens, for example. Tomorrow I'm meeting with somebody else. There is a chance it goes to a class action lawsuit, although the goal here is not to complicate the litigation. Class action lawsuit, by definition, complicates it because you got to certify the class and there's motions over that.
Mm.
Our goal here really is to essentially seek grievance for the four people that did come to us and say, listen, you just can't do this. So right now, our only clients are these four, but there's a likelihood it'll expand.
Yeah, and it's worth pointing out that what you're doing is a valuable check on the power of the executive branch, when in fact, what we've seen is an incredible lack of interest and action on the part of the legislative branch in order to investigate, which is to say that we know that the House Intelligence Committee or the Senate Intelligence Committee could find that this is very troubling that the CIA engaged in this activity against a diplomatic outpost or an embassy in the US. I mean, I can't even imagine what would happen if we found out that a country was targeting explicitly the United States' embassy while they were hosting somebody who was an asylum seeker, and that say a rival power was targeting people as they came in and out and investigating those visitors and violating their privacy. I mean, we know the outrage we would hear from the U.S. State Department, and yet there hasn't been any public assessment or address when it comes to this issue. So your lawsuit is really important for, I think, forcing that out into the open, because even if for some reason the CIA is able to stifle this lawsuit or Mike Pompeo is able to stifle your lawsuit, you've at least made this a public issue.
That's correct. And let's not forget, not only did they, as I just described, go in and image each of the plaintiffs' computers, laptops, phones while they left it with security, but the CIA actually had recording devices, audio and video recording devices in the conference room where they met Assange. So they have everything, and the individuals in what we learned in the Spanish case, this case in Spain, is that individuals who worked for UC Global, which is the company that was hired to do this, essentially were asking their bosses, why am I tape recording and sending these tapes back to Langley or back to Washington? I don't understand what Washington has to do with it. So there are individuals who were employees of this company that were stuck in the middle. They wanted to keep their job, but they couldn't understand why information about Julian Assange would go to the CIA. And so we have some very, very damning information against the CIA and Pompeo, and we intend on pursuing it.
And then one of the final questions I have for you as we wind this interview down is just to point out that, yes, people might be cynical. They probably, if they are following this Assange case closely and they're following some of the things related to this spying operation, they might have seen that the Spanish court has had some significant difficulties when it comes to getting information from the Justice Department to get compliance. I know they want to know the IP addresses, who were making those connections, where are those computers, what were those computers that were receiving this data. But why don't you take a moment just to point out, what you'll be able to do as somebody who's a U.S. lawyer and in a U.S. court in order to force the discovery of this information. So it won't be really that possible for them to not comply with giving you what maybe the Spanish criminal court is not able to get.
That's absolutely right. And what we've learned from the Trump era, 4 years, is that they are masterful at avoiding processes. We know that they've avoided everything the Spanish court has sought, even by way of subpoena. We know what they did with the January 6th committee, where they wouldn't produce documents or testify. We know what happened with the impeachment proceedings with Trump and the entire presidential organization. So they essentially are very good at either stonewalling or just refusing to produce documents, as much as recently where Donald Trump's tax returns were ordered to be produced and he appealed that again. So that's what's going on there. They do not have, to your point, they do not have the authority of a federal court judge. Let's not forget, a federal court judge, the federal court judge is appointed to this case, a guy named Judge Cattell, was, as is a true case of all federal court judges, was appointed by the President of the United States. They have tremendous power. They can compel Mike Pompeo, the CIA, to produce documents. If they don't, they could be held in contempt of court and could go to jail. So when you have a federal court judge, someone you just don't mess with, no matter who it be, you can't play the games that they played in Spain with the Spanish court. They played with the January 6th committee. They played with other organizations. This is a judge, and the judge is going to say to them, I want you to produce it, and I want you to produce it now. And that's something which is going to be it's going to help us out much more than any other dispute before another, especially a foreign organization.
And then, since you mentioned, it's important to work into our conversation here that Judge Cattell already had a case before him that involved WikiLeaks, and already came down on the side of protecting freedom of the press when the Democratic National Committee Chair Tom Perez tried to lump WikiLeaks in with alleged Russian agents, and with the Trump campaign when it came to their alleged examples of interference in the 2016 election. And he said, no, if you obtain hacked materials, which is what WikiLeaks did, then they have an absolute right to publish, just as anybody in the United States does under the First Amendment. And so it must be, you must feel pretty good knowing that you've got somebody who is going to preside over this case who has a history with WikiLeaks and isn't going to just see that this involves Julian Assange and have some kind of an irrational response to your efforts.
Yeah, I think we are very fortunate to get Judge Cattell. Not necessarily because of his prior decision, but because of his experience. He's a Harvard grad. He worked at a major law firm. He was involved in the Watergate special prosecution team. He was appointed by President Bill Clinton in 1994. So he's been at the bench, the federal court bench, 94, 04, 14, almost 30 years. You don't say no to a federal court judge who's been at the bench for a year. He's been there for 28, I believe. So certainly, he's it's a really great force we have, and if the federal government wants to reckon with it, then Judge Cattell is will definitely be on our side. So I'm not. Listen, he's very unbiased. He's very professional. He's unbelievably experienced, but nothing is going to slip past him. So we're lucky we have a judge with just such experience and stamina.
Right. Okay. So the last thing that I'll ask you is just, I think we have to make clear as we conclude that you're not on Julian Assange's legal team. You're representing these people who are coming before the court or will come before the court and argue that their privacy rights were violated and then present the evidence as best as possible. But that extradition case and the potential for Julian Assange to be put on trial in the United States is going to be a backdrop and could potentially be happening at the same time that this moves through the court. Is there anything you want to say about that dynamic and what it means for your lawsuit?
Yeah, no, you hit it on the head. There's nothing really. There's not much more to say except that think about this, if the CIA is in Assange's conference room, listening in on conversations he had with his lawyer for that case. Remember, he years ago he brought in a very experienced Washington D.C. lawyer to help him defend against this indictment, which was released maybe 3 years ago, but it was sealed initially. So could you imagine if the CIA, the government prosecuting Assange, already has conversations between Assange and his lawyer and even documents? So it really is there's a tremendous stink to it. In the other case, we don't represent Assange in the other matter. But I have, as a lawyer and as even an American, I have a fundamental problem with the government going in and actually taking information against, if you will, its adversary in that case. So we'll see how this plays out. I'm not sure what's going to happen with Assange. He probably will be extradited. He'll probably be tried in Virginia. It is a very complicated case. It's a difficult case. It's the First Amendment cries out in this case. So we will see what happens in that case. And this is somewhat intertwined to the extent that the government, his adversary, went and actually took information from him, which is the subject matter of this case, for that case.
I mean, it's kind of intertwined because your lawsuit is going to hopefully succeed in proving even more than we already know that the CIA was connected to this private security company. It's just like, I think it's like a half dozen or so people. It's a small little outfit that was engaged in providing the security for the Ecuador embassy. But hopefully, we'll be able to actually truly, through your lawsuit, connect that. And then I imagine, even though that's not the goal of your lawsuit immediately, it might open some doors for the Assange legal defense because they'll be able to introduce that into their evidence. Um, so, yeah, I think the cases move in the same way that the extradition defense and the extradition proceedings have, in some ways, been affected and influenced periodically by what's happening in Spain. Just because you cannot separate these issues, like you're saying, if the CIA is targeting the person who the US is trying to prosecute, it's hard to believe that you can get fair justice.
That's exactly right. And we will see how this plays out. They're very important cases, both of them, in our country. They have tremendous significance. Listen, we all believe in the CIA and its powers, and we believe it's a necessity for us to know what's going on in Ukraine and Russia, to know what's going on in the Middle East. But every federal government, every organization, every branch of government has to stay within its boundaries. And our lawsuit really tests those boundaries to see whether or not the government, the CIA in particular, and Mike Pompeo are really going way over the line. And that's what this is about.
But you mentioned that that your judge was involved in the Watergate prosecution. And, it seems like we're looking at similar excesses here. And so it's not unheard of. Americans are pretty familiar with the periods in history when their government agencies acted out of line, crossed into trampling on rights. And they know that it's the job of people, whether it be attorneys, journalists, or elected representatives, judges, and courts, to rein those people in.
That's exactly right. And that's what this case is about. It's interesting. It's not going to be easy. We're going to have a lot of obstacles. We're going to have a lot of roadblocks, but we will get there.
All right. Well, Richard, thank you for taking the time to talk with me. It's been good chatting with you.
Thank you, Kevin. Bye-bye.